Here's the decision handed down on Friday by the Supreme Judicial Court regarding First Amendment protection for certain communications that otherwise would be regarded as true threats under Massachusetts law. The ruling has the effect of bringing Massachusetts law into conformity with the US Supreme Court's 2023 decision in Counterman v. Colorado. Thank you to Lana Del Turtle for posting this online for us. This is SJC 13595 Commonwealth v. Erickson Cruz. Heard in Bristol County, October 7th, 2024 to December 13th, 2024. Present: Judge Bud, Gaziano, Kafka, Wentlant, Georges, and Dewar. The original case was tried before Judge Stone. After review by the Appellate Court, the Supreme Judicial Court granted leave to obtain further appellate review. Wentlant describes true threats, serious expressions, conveying that an author means to commit an act of unlawful violence against the recipient, generally falls outside of the aegis of the First Amendment to the United States Constitution. Where the words compromise a true threat is measured by an objective standard that turns on what the words reasonably convey to the recipient in light of the circumstances of their issuance. Nonetheless, the author's subjective mental state is relevant, whereas here the state seeks to punish the author. In particular, the United States Supreme Court recently determined in Counterman v. Colorado that the First Amendment requires the state to show that the author consciously disregarded a substantial risk that his communications would be viewed as threatening violence before it may punish him for conveying a true threat. The jury in the present matter, which was tried prior to Counterman, were not instructed that in order to convict the defendant, Erickson Cruz, for making a true threat, they needed to find beyond a reasonable doubt that he acted with the required mens rea. Accordingly, his conviction violates the First Amendment. Further, concluding that GL Chapter 275 Section 2, threatening to commit a crime statute, survives the defendant's facial challenge, and that the prohibition against double jeopardy does not preclude a pre-trial in the present circumstances, we vacate the defendant's conviction and remand for a new trial. 1. Background facts. In 2018, the victim ended a 5-year-long dating relationship with the defendant. Following the breakup, the victim blocked the defendant's telephone calls on a cellular telephone and generally avoided communication with him. Nevertheless, the defendant continued to send text messages to her. Occasionally, the defendant, who had lived with the victim during their relationship, had moved out following their breakup, parked nearby her home. Approximately 2 years after the breakup, the defendant sent the victim 2 text messages. The first message was sent at 4:29 a.m. The defendant stated in part, "I wish you all blank, blank. I'm so hurt and it's still hurt. F you, I hope you blank, blank." In the second text message, sent approximately 30 minutes later, the defendant told the victim, "It hurts so much, it hurts a lot." In footnote 1, it says, because the defendant contends that principles of double jeopardy preclude a retrial on the ground that the evidence was insufficient to establish the required mens rea under Counterman, we recite the facts the jury have found in the light most favourable to the Commonwealth. 2. The trial judge gave a limiting instruction that the jury would consider these 2 text messages solely in weighing whether the circumstances on the following day was such that the victim could reasonably have feared the defendant had both the intention and the ability to carry out the threat in the text message at issue. The following day, the victim and her band performed a fundraiser at an adult daycare centre. After the performance, the defendant's 2 children, with whom the victim had become acquainted during her years-long relationship with the defendant, ran to her and she hugged them. later that afternoon, when the fundraiser ended, the defendant followed the victim as she walked towards a vehicle to leave. He was screaming and yelling at her. Approximately 2 hours later, the defendant sent the text message that formed the basis for the prosecution's case that he violated the threatening to commit a crime statute. Specifically, the text message stated, "I swear to God, if you touch my keys one more time, I'll punch you in your effing face, blank. I'm not going to repeat myself again." The victim, who had not occasion recently to touch the defendant's keys, understood that the defendant was referring to his kids. Procedural history. Following a jury trial, the defendant was convicted of violating the threatening to commit a crime statute. After his conviction, but while his appeal was pending, the Supreme Court's decision in counterman was issued. The appeals court affirmed his conviction in an unpublished decision. The defendant sought further appellate review, which we granted. 2. Discussion. A. Mens rea and true threats. As noted supra, true threats historically have not been protected by the First Amendment. The First Amendment does not protect conduct that threatens another. True threats of violence is a historically unprotected category of communications. It's just citing case law here. Other types of potentially expressive activities that produce special harms distinct from their communicative impact were entitled to no constitutional protection. And then lastly, certainly violence has no sanctuary in the First Amendment. It goes on to say, true threats are serious expressions of the speaker's intent to commit an act of unlawful violence. Whether words constitute a true threat is measured objectively, considering whether in light of the attendant circumstances, the words justifiably cause the recipient to fear violence. Again, citing case law, whether the speaker is aware and intends to convey the threatening aspect of the message is not part of what makes that statement a threat. The Supreme Court recently concluded, however, that the First Amendment shields some true threats from liability. In the counterman case, they were discussing the chilling effect that absence of mens rea might engender. A true threat may be punished criminally only if the speaker had some subjective understanding of the threatening nature of the statements. Specifically, to convict a person for making a true threat, the state must prove that the person acted at least recklessly. That is, the person is aware that others could regard his statements as threatening violence and delivers them anyway. Take note of that, because this is going to come up in Aidan's case. Again, quoting some case law there, and the footnote reads, "The term true in true threats distinguishes jests, hyperbole, and other statements that in context do not convey a real possibility that violence will follow." Some case law is stated, "The term true threat has been adopted to help distinguish between words that literally threaten but have an expressive purpose, such as political hyperbole, and words that are intended to place the target of the threat in fear, whether the threat is veiled or explicit." So in Part B, jury instructions. Here, the jury were not instructed that they were required to find that the defendant acted with the mens rea necessary to convict him, as the law required before counterman. The jury were instructed only that, quote, "in order to prove the defendant guilty of threatening to commit a crime, the Commonwealth must prove 4 things beyond a reasonable doubt. First, that the defendant expressed an intent to injure a person or property of another, now or in the future. Second, that the defendant intended that his threat be conveyed to a particular person. Third, that the injury that was threatened, if carried out, would constitute a crime. And fourth, that the defendant made the threat under circumstances which could reasonably have caused the person to whom it was conveyed to fear that the defendant had both the intention and the ability to carry out the threat." Contrary to the Commonwealth's argument, these instructions did not require the jury to find that the defendant was aware that others could regard his statement as threatening violence and delivered it anyway. Accordingly, his conviction violates the First Amendment and must be vacated. Footnote 5 reads, "The Commonwealth places particular weight on the second requirement in the jury instructions, which concerns whether the defendant intended his message to reach the victim. The intent to deliver a statement to a particular person is, of course, different from a subjective understanding of its threatening nature." And again, it states some case law to back that up. So C, overbreadth. The defendant contends that the threatening to commit a crime statute is facially overbroad. In determining whether a statute is facially overbroad, we look not only to the language of the statute, but to any limiting construction we have grafted on that language in interpreting the statute. And we have not hesitated to construe statutory language narrowly to avoid a constitutional overbreadth, especially where we discern a legislative intent that the statute prohibit only constitutionally unprotected speech. The threatening to commit a crime statute provides, if a complaint is made to any such court or justice that a person has threatened to commit a crime against the person or property of another, such court or justice shall, not may or could be, shall examine the complaint and any witnesses who may be produced on oath, reduce the complaint to writing, and cause it to be subscribed by the complainant. Emphasis added. GL Chapter 275 Section 2. We previously have concluded that the legislature intended this statute to reach only cases of true threats that would not qualify as protected speech. Consistent with that determination, and in order to effectuate the legislative intent to criminalise any unprotected speech, we construe that the statute to require that the Commonwealth prove beyond a reasonable doubt, inter alia, that the defendant acted with at least the mens rea of recklessness. That is, the defendant consciously disregarded a substantial risk that the communication will be viewed as threatening and delivered it anyway. Accordingly, we conclude that the threatening to commit a crime statute is not overbroad. D. Double jeopardy. The defendant also maintains that the evidence at his trial was legally insufficient to permit a jury to conclude beyond a reasonable doubt that he possessed the mens rea required by the First Amendment, and that the double jeopardy therefore precludes a retrial. We disagree. Rooted in the Fifth Amendment to the United States of the Constitution and in our common law, the prohibition against double jeopardy generally precludes retrial if the Commonwealth presented insufficient evidence at the original trial. I will continue that sentence and read the footnote before we move on. Contrary to the defendant's contention, construing a statute to avoid unconstitutional overbreadth does not require the quintessentially legislative work of rewriting state law, whereas here there is no indication of a legislative intent. And then 7 says, we also take this opportunity to provisionally revise the model jury instructions for this offence as set forth in appendix to this opinion. So to finish the sentence, the prohibition against double jeopardy generally precludes retrial if the Commonwealth presented insufficient evidence at the original trial to support the defendant's conviction. The prohibition protects defendants against the possibility that prosecutors could treat retrials as dress rehearsals until they secure the convictions they seek. That kind of sounds familiar, doesn't it? Where the evidence presented at a first trial does not support a finding of the essential elements of the crime beyond a reasonable doubt, the prohibition against double jeopardy generally precludes a retrial. In short, the prohibition against double jeopardy precludes the Commonwealth from getting a second bite at the proverbial apple. In this case, the defendant's trial took place before the Supreme Court's decision in Kearney, which announced for the first time that the First Amendment requires proof that the defendant acted at the least recklessly. Prior to the Supreme Court's decision, it was established that the true threats, as a category, were not protected by the First Amendment. A true threat was measured by an objective standard and could be punished thereby. Following counterman, however, some true threats will be protected. This is a change in the law. Counterman, acknowledging law prior to the court's decision that true threats of violence, everyone agrees, lie outside the bounds of the First Amendment protection. Thus, at the time of trial, the Commonwealth had no reason to introduce evidence of the defendant's state of mind to establish his culpability for sending a true threat, or to insist that the jury be instructed to include the mens rea requirement. Moreover, as a general matter, when we vacate a conviction, double jeopardy precludes a retrial only where the evidence at the first trial was insufficient to establish essential elements of the crime. Here, although the defendant was tried prior to the court's decision in counterman, the evidence was sufficient to allow a rational jury to find beyond a reasonable doubt that he had the prerequisite mens rea. The evidence concluded that, despite the passage of nearly 2 years since the victim ended their relationship, the defendant remained upset about the breakup. He knew where the victim lived, despite the victim's effort to block communications with the defendant. He continued to send her text messages and occasionally park his vehicle near her home. In the pre-dawn hours of the day prior to the true threat at issue, he had sent the victim 2 messages. In the first one, he stated, "I hope you blank blank," and in the second one, half an hour later, he expressed desperation. A couple hours prior to the true threat at issue, the defendant had followed the victim as she left the fundraiser, screaming and yelling at her as she moved towards her vehicle. Then in the text message at issue, he explicitly threatened violence against the victim. In that same text message, he warned, "I am not going to repeat myself again." Viewed in a light most favourable to the Commonwealth, a properly instructed jury could have found beyond a reasonable doubt that the defendant consciously disregarded a substantial risk that his text message would be viewed as threatening violence and delivered it anyway. In these circumstances, double jeopardy does not prevent the Commonwealth from retrying the defendant. Conclusion. Based on the foregoing, the defendant's conviction is vacated and the matter is remanded to District Court for a new trial, if the Commonwealth chooses to pursue one. In the appendix, it says, the defendant is charged with having threatened to commit a crime against the person or property of another. Threatening a person with the crime against his or her person or property, a person by threatening a crime against someone else or their property, is itself a crime. In order to prove the defendant guilty of this offence, the Commonwealth must prove 5 things beyond a reasonable doubt. First, that the defendant expressed an intent to injure a person or property of another, now or in the future. Second, that the defendant intended that the threat be conveyed to a particular person. Third, that the injury that was threatened, if carried out, would constitute a crime. Fourth, that the defendant made the threat under circumstances which could reasonably have caused the person to whom it was conveyed to fear that the defendant had both the intention and the ability to carry out the threat. And fifth, the defendant was aware of or consciously disregarded a substantial risk that the communication would be viewed as threatening violence. This element requires that the defendant was aware that the others could regard his statement as threatening violence, and yet the defendant delivered it anyway. So, this ruling affects anyone charged criminally under Massachusetts law for harassment due to things that they might have said or written. The Commonwealth must prove those 5 elements beyond a reasonable doubt. This is a somewhat subtle but critically important change in how criminal harassment statutes are to be applied by Massachusetts courts. Thank you again to Lana Del Turtle for the commentary that goes with that ruling. The decision holds that statements are not free speech only if the accused recklessly disregards a substantial risk that their statements would be viewed as threatening violence. That's the most important part of, let's say it's a preamble. I don't know that this is actually a ruling yet. I think it's a preamble. But that is the most important part. So, feelings getting hurt is not really part of this, part of the new ruling that hopefully comes out of it. I'm not entirely sure why it's considered only a preamble, but it could be to do with this note on the front that says, "Notice, all slip opinions and orders are subject to formal revision and are superseded by the advance sheets and bound volumes of the official reports." So perhaps we are waiting for formal revision before it is case law. To wind this all back to Aidan Kearney's case, once reviewed and it becomes case law, I think it only really applies to the case involving Lindsay Kearney and whether or not he had the intention of threatening or harming her. For those who are not familiar with it, I will close out with a recording of said incident.
That's a fucking somebody.
I'm still recording this, you know.
Yeah, I know.
Huh? I have to get going.
Yeah, I knew you were gonna do that.
Do what?
I knew it.
Go be with my
Dude, I called it. You stood there and you lied to my face. You lied to my face. Remember that. It's odd. It's fucking odd. Remember that. Remember that.
Remember what? Remember what, Lindsay? I forgave you.
Fuck off. I don't need forgiveness.
For conspiring with me.
I didn't even fucking say a word after what you fucking did to me. For weeks.
What did I do to you?
For weeks. Are you kidding
I
me?
didn't do anything to you.
Oh really? Let's play the videos. Let's play the videos of what you didn't do to me. Let's play them. Shall we?
What videos?
Fucking shall we? Let's play them. Come on,
What videos?
I'm gonna play them for you right now. Hold on, let me just get to them.
What videos? What are you talking about?
You know, leaving me to
I can't hear
the
this.
after I took these pills after you lied to my face just now to try to walk out now. You realize I'm a mandated reporter, right? You want to fuck with me with my health and make me sit here and do this alone when all you have to do for 3 hours is to sit here? Fuck you! I'll fucking play your game, Aidan.
And then you reported what?
I'm not lying. I'm not gonna lie for you.
I don't want you to lie.
Oh yeah, that's why you're telling me that I need to fucking side with you and you'll protect me and you won't put my shit out there. That's why you're blackmailing me.
I'm not black.
Nice try.
Nice
try.
I specifically.
Nice try. You know, you blackmail me, and it doesn't have to be a direct blackmail either, or a direct threat. Do you not realize that by now? You fucking blackmail me, you said me that shit about my kids! You blackmailed me and you threatened me. And guess what? Guess fucking what?
Guess what?
All you had to fucking do was you lied to me. All you had to do was sit there. But for some reason, you have to fucking get going at 3 a.m. I wonder why. Because you're a fucking liar and a user.
No, because I have.
No, you're a liar and a user. You just stood there and said, okay, I'll stay. And then as soon as I put them in my mouth, you fucking do this shit. You're a fucking psychopath, or you're deranged. There's something wrong with you. You weren't built right. You were born with something with your wiring fucking off.
With me.
That makes you a fucking psycho.
Okay.
You're psychotic.
I'm psychotic.
No fucking fucking man acts this way. No man thinks his whole life is an online world with fucking online fucking people that function. Like, you literally think, like, that's the whole world. Like, because you're a dweeb. Because no girl ever fucking wanted you.
No girl.
And guess what?
I don't get any girls.
The only fucking reason anyone pays any attention to you is because your fucking stupid ass show. Otherwise, nobody would look twice at you.
You were a fan of.
No, I fucking wasn't. And guess what? I had messages from 2 months ago. I believe Karen is 100% guilty.
Yeah, because you're retired.
Guilty?
Yeah.
No, because...
No, because you're retired. Because you're
I'm retired. That's why I have 2 degrees. That's why I had 3 licenses.
From community college.
No, actually from real college.
Oh,
I have a bachelor's degree. Yeah. Oh, UMass Amherst?
Oh, you went to
Zoomass?
UMass?
You went to Zoomass, dude?
Yes.
All your siblings went to a prestigious school and you go to Zoomass. What was wrong with you? I wonder what wrong with you. You're the problem child.
Right.
You're the fucking, and you're just mental, as mentally ill as your fucking mother. Just like
My
her.
mother?
Your mother. The
You think
fucking
my mom's
crazy
mentally-
nut job that belongs in a fucking institution.
My mom?
Yeah.
How do you know my...
Yep. Oh, I did my research too. Mommy likes to do her research too.
Wait, my mom's
Yep.
a nut job?
Yep. I know all about it.
Oh my god.
Yeah, I do.
Okay.
Okay.
Well,
Oh, yeah, well. And threatening me when you want to fucking get your way, telling me to do whatever you fucking say, or else you'll release information about my
oh, definitely.
You made the big mistake threatening my children, bringing my children
didn't
into
threaten
it.
children.
You made a huge fucking mistake. Huge.
I definitely didn't threaten
Huge.
children.
Oh, you definitely did. You definitely did. Indirect or direct threat. You definitely fucking did. You knew exactly what you were doing.
Indirect.
And guess what? It doesn't mean just because you put it in words, by the way, this is not a threat, doesn't make it not a threat.
Oh.
Like, you think you're so fucking slick, dude. You're not slick at all.
You belong with Kate.
You're not
you
slick.
guys are
You're not slick.
basically the
Oh,
same person.
I'm gonna be 20 times worse than Kate. Because I'm gonna tell the truth about everything, because you just fucking did that.
That's fine, I can tell the truth. Too.
You wanna go there and it's gonna be so much worse for you.
Go there. Oh, truth. Okay. Tell the truth. What I do. Who are you calling right now? Who are you calling? This is what I want out of the apartment. I don't know. What are you calling? What are you doing? What are you gonna try to do? Are you gonna try to frame me for something?
Frame you?
Are
Are
you
you
gonna
serious?
are you gonna try to pull some bullshit like I hit you or something? Is that what you're trying to do right now? Who are you calling? No, this is Who are you calling?
For help now.
Who? Who? Show me who you're calling.
Do it.
Show me who you're calling.
Yeah, I do. I know. Leave me alone with court just I fucking hope something happens to me because I'm leaving a note.
Yeah, you've already threatened that one.
Yeah, I have, right? I have. No, you have. You have. I haven't done it, and I will. No, I haven't. I have a bunch of emails for you. You fucking do it. Do it, Aidan. Do it. Go ahead. Go ahead. I knew you were gonna fucking do that to me. I fucking knew it.
Go back.
I fucking knew it.
I don't live here.
You just promised me if I took those.
And then you spit
You
them
just
out.
promised me. No, the fucking one fucking tiny piece came out. I fucking took the majority of them. They're all gone, and you're gonna fucking do this to me. You're gonna fucking leave me in case something happens. You're gonna fucking walk out. Are you serious?
Like, what the fuck? What's gonna happen?
You understand? You understand what it does? Do you even fucking understand?
Alright. Well, I gotta get going.
You can't fucking leave me. I'm gonna fucking, like, you don't understand. It's literally like giving birth. I can't be alone.
I did not sign up for this.
You
stuff.
told me to fucking take it.
I certainly did.
Don't say you did. Don't say you did it. I said I'm taking them. You said I'll stay if you take them. Don't say that you did it. Don't say that you did it. Don't say that you did it. You said you
Give me the piece of paper.
Don't say that you did it. I'll give it to you after. Don't say that you did it because you're proving it to me right now. You're just trying to walk out. I can't be alone. I will give it to you after.
I will stay for a little while longer if you give me the paper.
No, I don't trust you now. You just tried to leave and walk out the door.
Well, I will leave.
I'll give it to you after. If you leave, no, I'm not doing that game. You're not playing a game with me because you just lied to my face.
What are you gonna do if I
You
leave?
you just fucking lied to my face. This is fucking part of you too.
What?
I shouldn't have to fucking go through this alone. You just don't want to fucking take responsibility for your part.
I don't think so.
I have to fucking go through this now and fucking I'm gonna be alone with 4 kids. I have no one at all to fucking be here with me.
Hey. You're, I'm not convinced you're pregnant.
Shut the fuck up!
Show me the
You're
ultrasound.
just trying to fuck with me.
Well, I think you're a liar. You're a pathological liar.
I'm not a fucking, you're a pathological liar. You just lied to my face and then you just tried to say that you didn't say you did. You did. You're a pathological liar. You are. And you project everything onto everybody else. That's what you do on your show every day. Every fucking day. You just have to keep going. Like, all you have to do is fucking sit up, put on your shower. I'll go in the other room. You don't have to fucking talk to me or do anything. I'm not asking anything of you other than just to be a body here, please.
Fine. Give me the fucking piece of
I'll give it to you after. I have no reason to fucking, that's the only fucking reason I fucking care is because I don't want to be alone with this because I have 4 kids and I can't be alone with this. I couldn't even tell the ass you in this because you wouldn't have fucking come. That's how fucked up you are. I couldn't even tell you in advance because you wouldn't come, just like the other day, the 2 weeks ago when you fucking said you were gonna come. I couldn't even fucking tell you in advance.
It's okay,
I didn't have to tell you jack shit. I didn't have to tell you anything. And why are you going on and on now? When I just fucking told you, all I need you here is for a body. That's all I need you here. You want the room? You want the room to yourself? I'll go here. You don't need to keep going and going. Like, that's a fucking antagonist. Are you fucking kidding me?
Where are you going?
I'm gonna take all my kids with me in the car and drive to your fucking house and sit in your driveway and let it happen in 3 hours in your driveway. You wanna fucking do this to me? I'll wake up all my kids right now. What do you think I won't? You're not gonna fucking do that to me. That is the most fucked up thing I've ever heard of in my life. Fucking forcing someone to take it and then fucking saying you're gonna stay and then fucking take it off. That's the most fucked up thing for anything.
I'm exhausted. I ain't gonna go.
I'm getting my kids and I'm following you to your house. I'm gonna do it in the driveway and I'm gonna fucking show you how I am out there. Driving. Cole, wake up. Guys, wake up. No, you're doing this to me. You're doing this to me. You just promised. You just fucking promised. No, you're gonna make me have too much free time. You don't get to do this to me. You're not gonna do this to me.
I will lie down. Stop it. Stop it. Stop it. Stop it. Lie down. Lie down. What are you taking? Stop it. Stop it. You're waking up your children.
Yeah, I know. They're gonna wake up anyways. And I might as well get to fucking hold it while I can because I'm not gonna be able to drive in the next fucking hour. I'll give it to you after. No, then that's your only option. Call KK! You really want to do this to me? You really want to fucking do this to me? Guess what? If I fucking crash now on the way there, because I'm fucking having contractions, it's documenting you, and I will stay in the driveway and I will tell Julie everything.
This is child abuse.
No, what you're doing is abuse. What you're forcing me to take those and saying you're going to stay with me and help me. That's abuse. That's abuse what you just did to me. You need to fucking stay to your word because that's fucked up what you just.
Okay. He needs to go back to bed.
And you need to fucking stop doing this to
He
me.
needs to go back to bed. He needs to get to bed. Put that boy back in bed right now. You heard me? Put that boy back in bed right now. This is not good for the kids.
You're damn fucking right it's not.
You need to put him.
You're damn fucking right it's not.
You need to put him back in bed right now. Right now.
You need to stop doing this to me. It's abuse what you're doing right now.
In front of the children.